Are you calling me from Phoenix?
I'm actually in our New York office this week.
How can I help you? I said, how can I help?
Well, there was a couple about the first. I don't know if you've seen the Rule 16 scheduling order from the court, but Judge Bolton has asked us to meet and confer about coming together with a case management plan, just setting out deadlines for discovery going forward in the case.
Filed prior to her scheduling that order, the Rule 16 order. The purpose of that rule is to minimize the cost of litigation, the time, and everything. We have been litigating this case for more than 8 months now, so I believe it was untimely. I do plan on filing a motion for reconsideration. You guys currently have you're actually late responding to a motion for summary judgment. So a motion for summary judgment is a dispositive motion, and you guys should have responded within 30 days.
That's actually the second thing I was going to talk to you about. But let's go back to the case management plan for just a minute, and I understand that you are going to file a motion for reconsideration for the judge's order, and of course that's your right to do that. Am I correct in saying that you don't want to set up a time to meet until after the judge has ruled on that?
What is the purpose? Because if you guys need discovery regarding a summary judgment motion, you're supposed to petition the court, and a Rule 16 motion should not be used as a way of you guys getting around a motion of filing a request for the court to give you.
Well, I understand that. That's not the purpose, our purpose, or the general purpose of a Rule 16 conference.
From my understanding, is to help expedite the management of the proceedings, right?
Yes.
If we have, you guys are the only remaining defendants, and if I've already filed a dispositive motion, the next step for me, if I don't like the ruling, or if you guys don't like the rulings after the dispositive motion for summary judgment, we're to petition the Court of Appeals. Why are we extending litigation?
Well, I understand what you're saying, and I understand your point of view, but if the motion were denied, we could go forward with the case.
I also exercise my options to file an appeal in the Court of Appeals regarding the motion for summary judgment.
Right. Well, I guess what I'm saying is, if your motion for summary judgment is not granted, that doesn't mean that we all have to go to the Court of Appeals. We can continue with this case and take it through discovery.
I don't want to do that. I do not desire to do that. You guys have not filed a motion petitioning the court for summary judgment. I mean, for discovery needs. You haven't asked the court, you haven't petitioned the court for summary judgment, for discovery regarding that summary judgment, or for any other purpose. You've also filed 2 motions, dispositive motions, for failure to state a claim. So I'm not understanding why you need discovery at this time, and I don't understand why you have not petitioned the court via affidavit or declaration for that discovery needs. I don't understand that.
I can try to explain it to you. This case, the procedural posture of this case has taken a different turn than some cases do because of the multiple defendants and other things. Typically what happens is after an answer is filed, we have this Rule 15 discovery order that we go through with the court, and we come up with our deadlines. And then
you also see that that's usually done within 120 days after the commencement of a lawsuit, or by local rules it's done within 180 days. This is being done 242 days after the commencement of the lawsuit.
I understand what you're saying, Ms. Shield, but I certainly don't want to get into an argument with you about the merits of what the judge has done here. I was just trying to explain to you how a case typically goes along. And the typical point of having this...
Well, already beyond typical.
Understand that. But what I was trying to explain to you is the reason why we haven't petitioned the court for discovery is because what usually happens is you and I, or the parties, will meet to confer about the case, and they'll exchange discovery at that
position, or from where I'm sitting, I do not want to meet with you guys regarding discovery. I have no needs for discovery, and if you guys have needs for discovery, I believe you're supposed to petition the court for that.
Well, under Rule 26, each party is required to give each other all of the documents that they have to support their case. Now, our deadline to do that hasn't passed yet, and it's sort of connected to this Rule 26 conference that you and I were just discussing.
Your requirement by law to respond to the summary judgment motion within 30 days, that has expired.
I was going to talk to you about, actually. According to our records, the summary judgment motion response is due tomorrow.
Oh, how did you come up with that date?
It's because it's 30 days plus time for mailing. And the typical time in federal court for mailing, from the day you filed it, we get some time for it to be mailed, in theory. It sounds kind of weird, but there's extra days pinned on. It's usually 5 days, if I'm right. It could
mail in a local document?
I'm sorry, I don't remember off the top of my head whether it's 3 or 5 days.
And for mailing, the extra time had to do with process of service. I didn't know that had to do with responding to a motion.
You know, I apologize because I have a secretary who takes care of all the docketing, and we have a program where we enter stuff in and the program tells us the date, so unfortunately, I can't explain to you exactly how we got to the 8th as our deadline, but that's what I'm told, that March 8th is the deadline for responding to the motion for summary judgment.
Okay.
And the reason why I was calling you about that part is because I was wondering, we are working hard, and as you know, because I just told you, I'm in New York right now, and actually, Ms. Quincy is also in New York. We're attending to other professional commitments at this moment, and I was calling to see if you would be willing to agree to give us a short extension of time to file our response.
No.
The court?
I believe that to do that when I did not see you respond in time, and how everything I have prepared a response for your motion for extension of time, because that was already, it was obvious that you were going to go that route.
Okay, I'm not sure exactly what you mean.
Okay.
I wanted to call you first to see if you would agree, and if you don't want to agree, that's fine. I want to let you know that we are going to ask the court for an extension of time anyway, and if you would agree ahead of time, we would, of course, extend the same professional courtesy to you should you need an extension of time in the future.
Thank you.
That's fine, then. If you change your mind about the case management conference, I will be back in Phoenix next week, and I can tell you that actually I was unable to get a hold of you last week when I tried to call, so I did send you a letter about the case management conference, which you might get in the mail in the next day or two. You can respond or ignore it as you choose, because we've now had a chance to speak about it. But if you want to meet and confer about the case management plan and the discovery plan, I'm happy to talk to you about it a little bit more, and we can set up a time to meet. I will be back in Phoenix next week and available anytime to meet with you.
At this point, I have no needs for discovery, and I just don't have any needs for discovery. So, tell me, what is the scope of your discovery needs?
Well, we would be entitled, just under basic federal rules, to any documents that you have to support your claims in this case. So if this case went to trial, anything that you would use as an exhibit in your case, you're required to disclose to us under Rule 26. And then past that, we are allowed to serve on to you, and you are allowed to serve on to us requests for admission, requests for documents, requests for, or what's called interrogatories, which are questions you can ask that we're required to answer. If you look at Rule 26, and then rules, I think it's 30 through 34 of the Federal Rules of Civil Procedure, those are the rules. And I understand I'm not trying to give you legal advice here. I'm just telling you, for your information, that those are the rules that kind of govern discovery, and those are the kinds of things that each party can ask of the other side.
I believe that I will take the route of going through the Court of Appeals if I do not, if I'm not granted a motion for summary judgment. I will oppose any motion that you file for an extension of time with with whatever merits I believe are meritorious, whatever. I'll respond in opposition to your motion for an extension of time. I don't believe that you guys should be granted that after waiting for the time to respond to expire. So I will go ahead and look forward to receiving your letter. I do not, I'm going to file a motion for reconsideration of the Rule 16 scheduling order. I believe it is out of place. I believe it is a manifestly unjust ruling and a clear error of law based on, like you stated before, regular procedures. Is well outside of that. So that's where I am. So appreciate the call. Is there anything else?
When you have my email address and my phone number, it's for my Phoenix contact information. So if you do want to discuss the case management plan or anything else in the future, please feel free to call me at that number.
And I know an email address that's not being hacked into, so I do not communicate via email, so it will be by mail, U.S. mail, or telephone.
Great. Thank you, Ms. Shields. I appreciate your time.
Thank you. Bye.
Bye.